So just to give you a roadmap, I'm going to briefly highlight some of, you've been taken to the documents, but I'm going to briefly highlight some of the important parts of the documents. Then I'm going to set out my case as to the construction of the statutory scheme before referring to the case law on discharge of duty. I'm going to stick to the order in my skeleton and apply that to the facts. And then I'm going to deal with my own friend section 184 point. We'll see whether there's anything left in the suitable alternative remedy principle at that stage. So starting with the offer letter of the 18th of March 2020, that's in the appeal bundle at page 219. You were taken to it. So front page in bold. Please note that by accepting this offer, the council's homelessness duty to you will be discharged. So it's telling the appellant that the duty will cease if he accepts the offer. And again, there's some more detail about that on page 224. So first of all, at the top of the page, it advises the appellant that if he feels it's unsuitable, there's a right to request a review and the time for doing that. Then the second paragraph on that page, it advises him that you may choose to accept the offer by signing the tenancy agreement and request a review of its suitability. However, you will be liable for the rent from the start date of the new tenancy, regardless of the outcome of the review decision. If the decision on review is the offer is suitable, the council will expect you to reside in the property, and the council's duty to you under section 193 of the Housing Act 1996 will cease. So again, it's telling him you can review suitability. If that's unsuccessful, you will have to move in and the homelessness duty will cease. You will also, says final sentence, that if he succeeds on the suitability review, he'll get another offer. And the reminder letter you also referred to, specifically, that begins at page 227. Page 228, final two paragraphs. Again, giving advice about the right to request a review upon either acceptance or refusal. And then it continues in the final paragraph, by making this final offer of accommodation available to you, the council has discharged the duty previously accepted towards you as an unintentionally homeless household in priority need of accommodation. So just a leap ahead into my case is, this is the original discharge of duty decision. Those two documents construed together. Then we need to look at the request for a review, which was made by an email from the appellant's solicitor, dated 10th of June 2020, page 231. So, of course, the point that my learned friend lights upon is that in the first paragraph, the solicitor, Mr. Flack, requests counsel to carry out a review in relation to the decision that the accommodation offered to Mr. Young at 25 Diprose Lodge is suitable for him. So that's formally, it's a request for review of suitability. But then the reasons for requesting the review, which go over the page, include 3. No viewing. Mr. Young objects to having been forced, as he considers it, to sign a tenancy agreement before viewing the property. And 4, communication. Mr. Young considers that communication between himself and the council has been, in his words, ridiculous. And it asks for a copy of the file. So the point that I make is even the appellant's solicitor's request for review goes beyond suitability. It goes to the process of making the offer and therefore whether or not the respondent's prospective decision to discharge duty is lawful. Otherwise, what's the point of making these points? He was forced to sign a tenancy agreement without viewing the property beforehand, and the communication has been ridiculous. An unfocused submission perhaps, but the thrust of it is interpreting it reasonably. You haven't gone through the right procedure, so you cannot discharge duty. By way of background, the subsequent emails between the reviews manager and the appellant's solicitor include, on the 12th of June, page 229. So this is a clear acceptance of the offer, or record of that being agreed. Final paragraph on that begins on that page. Mr. Young should return the keys to his temporary accommodation to the council, not later than the 6th of July, 2020. So again, it's all consistent. Our duty to you under Part 7 has ceased in consequence of your acceptance. Why else would he be asked to return the keys? Then, as you saw, Mr. Flack, as it were, came off the record, and there was an email, several emails directly from the appellant to the housing reviews manager. Page 236. Is the email which we can date from another source as being dated the 1st of July 2020. And towards the bottom of page 236, the appellant makes the point, Wandsworth Council used coercion to get me to sign the tenancy agreement and then restricted me from viewing the property. So again, the appellant directly is making a point about the procedure leading up to acceptance of not being lawful or proper, which goes to the discharge decision. Then we move on to the review decision of the 20th of July 2020. Again, my learned friend stresses paragraph 1 on page 241, where the writer says, I write further to your request for a suitability review, and he rather heroically attempts to interpret this entire decision being governed by that opening statement, whereas we see at page 243, paragraph 25, the reviewer, as they should, sets out the representations contained in the email of the 1st of July 2020, which include, over the page 244, the particular point we looked at: Wandsworth Council used coercion to get me to sign the tenancy agreement, etc. There is then, as my Lord Justice Newey referred to during my own friend's submissions, a section of this decision letter, which begins at paragraph 57 on page 247. You have made allegations in relation to the tenancy offer process and have stated. And then it goes on to analyse that, reject it over the page 248, paragraph 68. I am satisfied that the offer process was both in accordance with the Council's usual procedure. You were notified of all relevant information and the potential consequences of any refusal and your right to request a review. I am therefore satisfied that you voluntarily signed the tenancy agreement document, and as a consequence of that, you are now the tenant of 25 Diprose Lodge, and that consequently, the previously accepted duty has now been discharged. So it's telling him those submissions are rejected, the duty has come to an end. That is carried forward into the operative part of the decision, if you like, page 251. It's paragraphs 101 to 104. But what we're interested in is the final part of paragraph 102. In making this offer which you accepted, discharge the previously accepted duty. Then it continues at 103. This is the Council's decision on review, and under the 1996 Act concludes all internal review processes. And then final page 253, paragraph 121, informs the appellant he has a right to appeal to the county court on a point of law and the time limit for doing so. So those are the essential facts. I didn't take you to it, but one of the points which occurred to me, looking at the facts of the case, is why did the respondents make a decision that the appellant had accepted the offer as opposed to having refused it? Because by this time he'd actually returned the keys. The answer to that is because I don't think I'm overstating it by saying that both the appellant's solicitor and the respondents were working together to try and accommodate the difficulties of the appellant. And I can just find the reference. Yeah, 239. So this is the appellant's solicitor's email of the 9th of July 2020. The paragraph level with the lower hole punch. You can see that. So the respondents might have said, well, you've handed the keys back, so you've refused this offer, and that's it, that's the end of it. But the appellant's solicitor asked them not to act on the return of the keys as a refusal, or indeed something which made him intentionally homeless, but to give him a final opportunity to accept it by making the review decision in the terms that they did. So I think I'm not overstating it by saying everyone was trying to work to accommodate the appellant's difficulties in terms of the procedure that was operated.
The language that's used is to final opportunity to the continuing the tenancy, accepting it. That language implies that there is something to continue.
Yes. Well, so a decision that he had accepted the tenancy would not be inconsistent with that tenancy continuing as at the date of the review decision, despite the keys having been handed back.
That's the point.
Yeah. So it gave him a final opportunity to move in, so that he didn't lose his housing. That was the gist of the request, as I understand it. So you now see the factual basis for the submissions I made before the short adjournment, in the sense that in this case, there was an offer which told the appellant the duty was going to cease. It told him that he had a right to request a review of that. One can argue about exactly whether it did enough to tell him or his advisors that he had a right to request a review about the cessation of duty, the discharge decision. But in actual fact, he did request a review of the discharge decision, in the sense that he challenged the process leading up to the making of the offer and the acceptance. Both of those points were dealt with in the review decision, which told him expressly he had a right to appeal to the county court. That was his obvious remedy. And he simply didn't appeal. Against that factual background, my learned friend's submissions on the law that in some way the statutory scheme should be construed so that he should have been given a further notification of the cessation of duty and his right to request a review, or that he didn't have a fair opportunity to challenge the cessation of duty, really, they don't work, because on the facts, he was clearly told about cessation of duty. He challenged it. He then got a review decision which told him what the avenue was to challenge that via Part 7 machinery, and he simply didn't take it. So, and that, in a sense, is the answer both. I'm not saying it answers all the technical points about the construction of the legislation, but in a sense, it's very closely linked to that, because this is an example of the legislation working as it should, in my submission. And secondly, he had a fair opportunity to challenge the cessation of duty by appealing the review decision, as he was told. And that therefore means he had a suitable alternative remedy. I accept the suitable alternative remedy principle isn't a kind of mechanical principle. The court looks at whether the individual has had a fair opportunity to challenge the issue via the statutory machinery. And in my submission, on the facts of this case, he did have a fair opportunity. So that's...
Might there be a more fundamental point, which is that I haven't looked at Garlick, but if you're right that Garlick decides you can't raise questions about capacity at all in this forum, to use the word loosely, there's no basis for challenging a view that the duty has been discharged, because there's no basis for challenging the fact of the offer, the fact of the acceptance of the offer, and that as a matter of law brings the duty to an end.
That's my so what point, my lady.
Yeah, so that's the fundamental point. So never mind all the stuff about notification and decisions and blah blah blah. There's nothing to challenge on these facts.
That is my so what point, my lady.
Good.
So I do have copies of B&W District Council in court if you want one, or it can be provided electronically, whichever is more convenient.
As you've got them, and that's why here, could you take that one?
Of course. Well, I might have, I think I've done 3. So I'm very happy to try to assist the court whichever way their minds are running at a particular point in time. So we can briefly look at this. It's really, the head note suffices. I just invite you to read it. So the point that was taken below in the defence, that the appellant lacked capacity to accept an offer of accommodation, was self-defeating in the sense that if it had been correct, the answer would have been the same, no duty. And in a sense, we don't need to get into the detail of it. The way in which capacity interrelates with the decision-making procedure under Part 7 is not that straightforward. So you do not see, this is, as it were, a condition written into the statute by case law, by the House of Lords, which does not appear expressly in, for example, Section 193. There is therefore nothing in Section 193 which talks about the local authority, if the local authority well, the local authority's duties shall cease if they are satisfied that the applicant no longer has capacity. So that one can have complicated issues which might arise. I simply note that in B and W District Council, being faced with this conundrum, the county court judge simply found as a fact that the applicant lacked capacity and therefore no duty was owed. It's almost the inverse of what happened in this case. I mean, when one thinks about how capacity interacts with the decision-making procedure under Part 7, first of all, the local authority can't accept the main housing duty without being satisfied, or at least the presumption applying, that the applicant has capacity to accept an offer. Number two, they cannot lawfully make an offer to a person whom they know or are satisfied does not have capacity. So if it was decided at a particular decision-making stage, here it would have been decided by the offer letter. So it's not even an issue which was subject to what has been called automatic discharge. It was decided both by the offer letter and by the review decision necessarily. And one can easily see the force of it, because if a local housing authority owed the main housing duty to someone who didn't have the capacity to accept or refuse an offer, they'd be obliged to make multiple offers to a person who had no basis for either accepting or refusing them. So the applicant's remedy is either to go down the social services route, Care Act 2014, or to apply to the Court of Protection for the appointment of a deputy under section 19.6 of the Mental Capacity Act 2005, who then has power to make an application on their behalf. So there we go. My learned friend, in answering the so what point earlier, suggested that there might have been a point that reasonable adjustments should have been made by the respondents. My point about that is the appellant was told the duty was going to an end. He in fact did challenge the procedure leading to the offer and his acceptance. But at no point during that exchange did he, or was it suggested on his behalf, that the procedure was inadequate because the respondents failed to make reasonable adjustments as they were obliged to under the Equality Act 2010. That being the case, the usual rule applies, which is it's too late to suddenly suggest that would have been too late to suggest that on appeal to the county court under 204. So how can it not be too late to suggest that now in a public law defence? It's another variety of the suitable alternative remedy point, that these points have to be decided somewhere and there's some finality about it. And Parliament has laid down the procedure which is available to homeless applicants to challenge these decisions. So at this point, I believe I move on to the construction of the Act. And I don't know whether I should be tentative, apologising. In a sense, all I needed to say was I adopt the analysis of the legislation set out in the judgment of my Lord Justice Newey at paragraphs 38 to 53 of the case of Barno, of which you have a copy. And in a sense, that's the end of it. And anything I have to say is merely footnotes to that. But the interest of this case is I'm not aware. So whilst there is Wasame, and there is Ravichandran. So Wasame was pre the current version of the legislation. It may answer the question in this case in the sense that, well, let me just be clear. What I'm saying is it's lawful for a local housing authority to go straight from the offer to a review decision, which is a discharge review decision. That's my submission on the legislation. You can go straight from one to the other. That is suggested in Ravichandran, but in that case, Lewisham didn't operate that machinery in that way. They messed it up. And so the Court of Appeal suggested a construction of the legislation which I say permitted what happened in this case, but it's not on the facts. It didn't happen. And of course, Barno, there was no in-time request for a review or extension of time, and therefore you didn't have the offer followed by a review decision on cessation of duty. So this is the first case of which I'm aware where that's actually happened and the Court of Appeal has had an opportunity to consider it. That's really the interest in this case from a practitioners and or local housing authorities point of view. So I can deal with the legislation however, in whatever way helps you most. I have set out what I say are the key provisions at paragraph 39 of my skeleton, or we can go directly to them. You may find that more helpful. Tab 1 in the authorities bundle. So it's page 5. Current provisions, section 193. Duties in subsection 2. Subsection 3 introduces the following provisions which provide for cessation of duty. We're not directly concerned with subsection 5, which is offers of temporary accommodation. But it is part of the context that the current provisions provide in subsection 5C that the authority must notify the applicant that they regard themselves as ceasing to be subject to the duty under this section. And I say that's present tense. That is a prospective notification. In other words, that is consistent with my case, that notification is given by the offer.
Can we just hang on a minute?
Of course. So I don't want to try and do too much at once, but maybe we can just do it. So if one looks at page 21 for the originally enacted subsection 5. The authority notify him that they regard themselves as having discharged their duty under this section. So as originally enacted, albeit not in the context of a final offer of Part 6 accommodation, in the context of an offer of temporary accommodation, the legislation said what my learned friend says, it now says. And then Parliament amended that to substitute what is now in 5C, present tense, ceasing to be subject to the duty under this section. And my broad submission is the legislative changes are consistent with Parliament having adopted the emerging case law, which provided for local authorities to notify applicants in offer letters that their duty was going to cease. Prospective notification at the offer stage.
And I assume there are no explanatory notes explaining any of this.
No. But all you can note really is the change in tense. As having discharged their duty under the section. So that's clearly retrospective notification under subsection 5 at the original decision-making stage. In the original legislation, page 21. And now we've got ceasing to be subject to the duty under this section. They regard themselves as ceasing to be subject. Present tense.
There's another difference, which is 5C as it now is refers to ceasing to be subject to the duty, whereas subsection 5 as originally enacted refers to the local housing authority regarding themselves as having discharged their duty. Which is
So this is interesting. So practitioners, housing authorities, all still refer to discharge decisions. And it's a bit snappier than a cessation of duty decision. Under the Housing Homeless Persons Act 1977 and Part 3 of the Housing Act 1985, all there was a duty to secure accommodation. Case law then developed the concept that the local authority discharged the duty by making an offer of accommodation. Originally, that was an offer of council housing, because in those simpler times, back in 1977, the assumption was you were owed the main housing duty, you got a council house. And that was actually written into the Code of Guidance, which your ladyship may recall, probably doesn't, but I recall being before your ladyship in a case called Hodge last year. And we looked at all that in relation to what kind of offer of accommodation could cause the duty to cease. So it wasn't until a wooer that it was completely worked through that under Part 7, what's now Part 7, under the homelessness legislation, you don't get an offer of settled accommodation. Anyway, that's by the by, but originally it was about the case law was the local authorities discharged their duty by making a suitable offer.
And I'd forgotten here, in the original version, it didn't say anything about informing the applicant of the right to request a review.
No.
So that's been deliberately inserted.
Yes. But it's a refusal provision, though, isn't it? Yeah. Algile. Is that an acceptance case? Byfield.
Let me see what's in.
Yeah. Okay. So my main point is about the change of tense.
No, yes.
Yeah. But your lordship has any other questions? Far away.
I follow the point about the change of tense. I hadn't previously thought about the insertion of the reference to informing of the right to request a review.
Yes.
And of course, you do find the contrast where you keep notification here, but you dispense with it elsewhere.
Yes. Then subsection 7, as now is, we have the requirement or the condition that having been informed of the possible consequence of refusal or acceptance and of his right to request a review of the suitability of the accommodation, refuses. And as your lordships and your ladyship have already picked up, as originally enacted on page 22, it had two parts, A and B. A is similar to the current provision, but it didn't refer to possible consequence of acceptance. It was added later. And then B imposed an obligation of notification after the refusal, albeit not expressly. It wasn't exactly the same as the original subsection 5. It wasn't notification that the duty has been discharged. Just that the authority was satisfied the accommodation was suitable and reasonable for him to accept. But it was an obligation to notify after refusal. And that has now gone from subsection 7. Now, my learned friend might say, I will deal with this now. So my learned friend might say, well, none of that matters because we're just looking at 6C, but that, with respect, that cannot be right. First reason, what is the point of the housing authority being obliged to inform the applicant of the possible consequence of acceptance if that is not relevant to 6C? Why should that make any difference to a refusal case? Surely the point, what Parliament really intends, is that the local housing authority have to inform the applicant of the consequences of acceptance before the duty ceases under 6C, if it's a final offer of accommodation at Part 6. And the second point is this. As you've seen in this case, the appellant accepted the offer, but the local authority went on to carry out a review of suitability. Where did you find that in 6C? It isn't there. It's only in subsection 7. So these provisions do need a bit of interpretation to make sense in accordance with their apparent purpose. And in relation to that last point, you'll see on page 13 subsection 202(1)(a) the applicant has a right to request a review of suitability, whether or not he's accepted the offer, and that specifically includes accommodation under 1937. So Parliament hasn't amended subsection 6.3. It's still there as enacted, but subsection 7 must be relevant to a discharge of duty case where the applicant accepts a final offer of accommodation under Part 6. There's nothing in subsection 6C that says the accommodation's got to be suitable. Suitability, don't forget, is a Part 7 concept. It's not a Part 6 concept. It may be something which local authorities write into their allocation schemes, but per se, suitability is a Part 7 concept.
And that's right. Somewhere there's something saying that you have to provide the suitability.
Yeah, 206.
That's 206.
Yeah, in discharging housing functions under section 205.
You're right, it's under that part.
Is it? Have we actually provided it? I'm not sure we have.
Sorry, I've got
But you've got, yeah, so it's 206. I can't remember.
yeah,
Is
you're
it
right.
performing the housing functions?
Discharging their housing functions
Discharge.
under this part.
Yeah. And so query whether making an offer of Part 6 accommodation isn't actually discharging functions under Part 7. It's merely that the acceptance or refusal of a Part 6 offer causes the Part 7 duty to cease. So that was another complication introduced by the 96 Act. As I was saying, that the good old days, all there was a duty, the local authority discharged it, and that was an end of it, subject to case law about when it revived. Now we've got a more complex scheme in which the phrase discharge may no longer be appropriate. It's certainly not always accurate in relation to the cessation of duty. So (193) in my submission is where we look to see. Obviously, we look for the express provisions which govern the cessation of duty at the original decision-making stage. Then there is a right to request a review of such a decision. And that we find on page 12, 2021B. So this subsection applies not only to the stage 1 decision, what duty do we owe you, but also to a state that might not even be stage 1 now, because we've got the initial duty. So really there are 3 stages now. You've got initial duty, kind of main housing duty, then you've got discharge of that duty coming to an end. 2021B applies both to a decision under section 184 as to what duty is owed, and to a decision under section 193 that a duty is ceased.
Sorry to bang on about this.
Absolutely.
Is any decision necessary where section 193(6)(c applies? It just follows as a matter of law from the fact that the offer's been accepted.
I think
what intervening decision by the local housing authority is necessary?
I think the difficulty with that approach is if there is a dispute about a fact which is relevant to the duty ceasing, someone has got to be able to decide it. The question is, who is that body? And the usual answer under the Act is the local authority. Is the primary decision maker. Otherwise, an applicant who disputes, I think my Lord Justice Newey's point is it's just difficult to see how that can arise. But there is a reported case, Borough of Wandsworth, which Lord Justice Newberger and others, in which there was a very hotly contested case where the applicant said, I did not receive that offer.
Right.
So you can see it is possible to have a dispute, certainly under subsection 7. I didn't receive the offer. Now, I'm making concessions on behalf of local authorities here. I hope
but that's not a problem if it's subsection 7, because you've got a right to request a...
Well, don't. On my case, I have to inform the applicant of the possible consequence of acceptance, and of his right to request a review of suitability. So if I haven't done that, the duty doesn't cease, because I'm trying to do a holistic interpretation of piecemeal legislation.
I understand the point you're making in relation to
so an applicant could say, you posted that offer letter to me which set out all the correct warnings. I did not receive that, and therefore, although I refused the offer, I wasn't properly warned, therefore the duty hasn't ceased. Now, if you have a dispute like that, there's got to be a mechanism for someone deciding that. And on behalf of local authorities, I say it's the local authority that makes that decision. The alternative is the applicant rushes off to the High Court in judicial review, and that would be countered to...
Or raises a public law defence.
Even worse, much later, years later. Quite. So the usual, and although it's not directly on point, I'm reminded of Lord Brightman and Pulhofer saying the Act abounds with the formula: the local authority must be satisfied of this or that, and that is the general scheme of the Act. In relation to automatic discharge, I want to be clear, because there is a danger here. It's a very snappy judicial gloss which we should attribute originally to Andrew Arden, QC, but adopted by Lord Justice Stanley Burnton. What it means is that the main housing duty ceases without a further notifiable decision. What I'm not saying, I'm saying on my construction of this legislation, as happened in this case, the applicant gets told in the offer letter the duty is ceasing. In the case of a final offer of accommodation under Part 6, in other words, the offer is made under 1937. At that stage, the local authority don't know whether it's going to be accepted or refused. So it's got to comply with subsection 7, right? The applicant is told our duty is going to cease. Whether you accept or refuse, it's going to cease. So that is a notifiable decision, and we know that by reading section 193. On this point, my lady is hotter on the textual points. I've gathered that. So
I'm just trying to understand.
No, I totally agree. I totally agree. But if one reads subsection 7, having been informed of the possible consequence of refusal or acceptance, your ladyship could make a point to me. That doesn't say notified. Here I borrow from my learned friend, and I say in this context, notify and inform are synonyms. And I'm afraid we can't expect beautiful syntactic clarity in this Act the way it's been thrown together. So I say that is the obligation to notify the applicant of the prospective discharge of duty. I'm doing this all on the basis of it's me telling you what the Act means, but we will look at the case law in a moment, and I'm going to say it supports me. But this is just doing it on the basis of, these are the words of the Act.
At the end of the day, we've got to make it work in practice, so far as we can.
Okay. I adopt that wholeheartedly, my lady, and that's my N3 point, which your ladyship didn't like. but it's got to work in practice.
Sure. No, I understand that.
And so I prefer, bearing in mind the multiple warnings about judicial glosses, I always think of Lord Bingham in the Crown against May, which was their proceeds of crime confiscation case, where he said guidance should be sought in the words of the statute, the language of the statute, rather than the proliferating case law. Yeah. And I was involved in when Pereira eventually got overturned in Hotak. And that was very much judicial gloss, where everyone gets there's a danger of getting mesmerized by this phrase, automatic discharge. My case is that the applicant gets notified, as happened in this case, that the duty's going to cease, that he's got a right to review that. Ideally, he's told, you've got a right to review the cessation of duty. He then accepts or refuses, requests a review. The review decision comes in after acceptance or refusal. You get two decisions. Because the other point, and this was why the Court of Appeal came up with the construction it did in Ravichandran, that Mr. Arden QC's main point is, where does this ever end? So you'll see from the case law, there definitely is, because the Court of Appeal has decided multiple times, a right to review the offer decision, including the prospective discharge of duty. Right, that's one review. There's also a right to review suitability. We know that. It says that in 2021F. And then my learned friend says there's another right to review after acceptance or refusal. You've got to produce another decision. You've got to have another review. So you've got 3 reviews, an enormous administrative waste. So when your ladyship says we've got to make this legislation work, I adopt wholeheartedly. The problem which Ravichandran sought to address is the problem of multiple reviews, all on the same topic. And how does that fit in with Godson? You know, do local authority officers have to kind of trail through the previous decisions and see, you know, what did I decide last time or not decide? Do I have to do another review? So potentially we've got, at least on my learned friend's case, at least 2 reviews on the same issue, which is what I'm trying to avoid. And I say the solution is offer, which does everything you're supposed to do, straight acceptance or refusal, straight to review. That's my case on the legislation.
So can I just be clear?
Yeah.
You say that at the stage you make the offer, you can see in section 193 what you have to do.
Yes.
And if you have done all that correctly, and the person accepts, you don't have to notify at that stage anything further.
You don't have to provide a further notification. And there's not a further notifiable decision, what I've called a retrospective discharge decision at the offer stage. That can be done at the review stage.
So just take it by stages.
Yes.
So suppose there's no review. So you make your offer in complying with these requirements. You say the person accepts, doesn't ask for a review, nothing further is needed from the local authority.
I adopt what your lordship said, paragraph 38 to 53 in Barney. but that is, I mean, that is that case. So what your lordship said was, first of all, the suitable alternative, the suitable alternative remedy principle is a bit of a get out, because they're very closely linked. But this is a get out. So I can say in this case, you don't need to decide that, because I had a review decision here. There was a review. There was a right of appeal. That's it. I don't care whether if there hadn't been a review, the respondents would have been obliged to produce a confirmatory decision. But consistently with principle, my submission is your lordship was right, subject to clarifying the judicial gloss, which we ultimately attribute to Andrew Arden QC. What automatic discharge means is that the duty comes to an end without a further notifiable decision by the authority. in practice, and I'll be quite clear about this, the authority will decide their duties come to an end. No local authority decides to terminate temporary accommodation without being satisfied the duties come to an end. The question is, under the scheme of the Act, which provides for a right of review, how many times does the applicant have to be told? How many times does he get a right to review it? That's the conundrum.
Then taking it by stages.
Yeah.
So if on the other hand, the person who doesn't like the accommodation very wisely nevertheless accepts and
Yes, quite.
asks
That's
for
all applicants are
review
advised
of
to do.
suitability. Come the review decision, on the face of it, the scheme of the Act is that's that for review, you go on to appeal, because section 202 says you can't have a review of a review. But it won't be the least bit surprising if the review officer says, having decided that the accommodation is suitable, that means that the duty has come to an end.
Yes.
So, on your case, why is that not reviewable?
You mean divorce from the facts of this case?
Divorce from the facts of this case.
So let's say, yeah. So I think what your lordship's putting to me is the applicant only requests a review of suitability.
Yeah, let's assume that first.
Yeah. So, well,
But nevertheless, the review officer will
decides it anyway.
Say, I think the accommodation was suitable, therefore I confirm that the duty has come to an end. Or something.
So there are two. So you may not pick this up, but in my skeleton, I put it three ways. I say one, they requested a review of discharge of duty, and that's what we did. End of story. It's a simple case. This is how the system's supposed to work. I say number two, even if that's not right, and on a correct construction of their request, we have a discretion to, as it were, roll up the reviews. Now, I confess, you can't derive that from the language of Stanley Burlington's judgment in Ravichandran, but his solution to Mr. Arden QC's submission, this is absurd, you can't have all these reviews, only works if that's the case. Otherwise, a well-advised applicant can kind of, pick and choose. Right, I'm going to choose, I'm going to have 3 reviews. So at this point, I'm only going to review suitability. And I'll review the discharge of duty later. And then I'll argue that I can have another bite at the suitability cherry when I do that. So I think to make the system work, if there is a request for a review of suitability, the local authority have a discretion to roll that up with discharge of duty.
Okay. I mean,
if that's wrong, then the last point is Lord Justice Newberger's solution in Rahana Begum, which is if you produce a review decision which says this is a review decision on discharge of duty and you can appeal it to the county court, then the local authority is stuck with that. And if the applicant does appeal it to the county court, they can't say, oh, well, that's not a valid review decision. They're stopped from denying that. So on any of those bases, there's some kind of remedy.
Yes. Can I just understand your case more fully?
Yes.
In a typical case, somebody asks for a review of suitability. And while I can't remember all the review decisions I've seen, a reviewer who decides that the accommodation is suitable typically sticks in something saying that means the duty is at an end.
Yeah.
So in that typical case where someone has simply asked for a review of suitability, the local authority hasn't gone through the thought process of saying to itself, am I rolling up suitability into different matters?
And have I advised the applicant that I'm going to be doing this, so it's all terribly fair?
It's just saying, I've been asked to deal with suitability, I think it's suitable, therefore the duty is at an end.
Yes.
Now, on Mr. Bates' case, he says, well, at the point at which you say the duty is at an end, that's a decision and Section 184 applies and so on and so forth. What is your case on the review officer who says that means that the duty is at an end?
So if there's been no request for a review of that issue, and the local authority haven't told the applicant they're going to be doing that, I think technically, this is Rahana Begum, that technically that would be an original discharge decision. The applicant might be able to appeal it on the basis suggested by Lord Justice Newberger. Well, I say is able to appeal it on the basis suggested, I think it's paragraph 38, Rahana Begum. It's 38, yeah. So that's not exactly how the system should work, because at that point, my learned friend's criticism potentially applies. In other words, if there is a real substantial issue here about the cessation of duty, which I say isn't this case, but let's imagine a case where the applicant, like Bob in Wandsworth, I didn't get the offer letter, I was never warned about the consequences, and the local authority do not warn the applicant, or notify the applicant they're going to be reviewing discharge of duty. So they're caught by surprise when this decision comes back, the duty's ended, without them being given an opportunity to argue, I never got the offer letter. At that point,
that scenario sounds unreal. I mean, why are you asking for a review of suitability if you haven't got the offer?
Yeah.
So what is a realistic scenario?
Well, I can't remember what the facts of Bob were, but clearly I think that it must have been, they sent her an email, come and see the place. She turns up, looks at it, refuses it. Meanwhile, they've sent a formal offer letter in the post. She said, I never got it. So that's the realistic scenario. That's where the difficult case that your lordship putting to me applies.
But what worries me then is you're sort of accepting that in the routine case there's a problem, in the sense that you where the local authority has simply been asked to review suitability, thinks it's reviewing suitability, and thinks that that being the only issue, it follows that the duty is at an end. You're sort of accepting that.
Well, there hasn't been a review decision on cessation of duty, has there?
No, well, that means it's an original decision on a cessation of duty, you say, and that's reviewable. Even though the review officer is simply thinking that they're giving effect to what follows from this dispute.
In a sense, all this would be sorted out if every offer letter says you have a right to request a review of our discharge of duty, and if you request a review of suitability, we will be reviewing whether our duty is ceased. If you do that, there's nothing unfair in the system. They go on to do the review decision on discharge of duty.
I'm not sure the letters would be even more confusing than they otherwise are.
Well, possibly, but that's my learning. Otherwise, I get my learned friend's criticism. There's something unfair going on here. And what we're trying to do is make the system fair without requiring the local authority to do multiple reviews, essentially on the same issue.
But why is it unfair if the applicant for housing has been told of the consequences of refusing or accepting the offer when the offer's made, and refuses or accepts the offer with those consequences in mind, and then Parliament's provided in section 193 for the consequences? Why is it unfair? If the person's told, by the way, if you accept this offer, our duty will be at an end, they accept the offer, duty is an end. What is there to, I'll go back to the question of what is there to review, and then you come back with your point, well, there might be some dispute about the underlying facts.
Well, there might be a dispute about whether the procedure's been correct. I mean, there was here. I mean, in a sense, the cowardly way to go about this, we don't need to worry, the court doesn't need to worry about all this, because in this case, it all happened how it should.
Yes.
Yeah, near enough.
Into the box mark 2 days.
And but I can see that it's early enough in the week that you're not intellectually satisfied by that answer. I think the difficulty I have, and viewing what might happen to this case, is I have a difficulty with the concept that a duty ceases which involves questions of fact about whether an applicant is notified of certain matters. And there's no one to decide that. There's got to be someone to decide that. And the obvious answer, given the structure of the Act, is the local authority.
In the real world, you can achieve that quite easily because a confirmatory decision, we're told, is reviewable.
Yes.
So when this hypothetical issue arises, and the local authority says, we think that such and such is the position and therefore our duty is ended, even if there has been, in some sense, a previous ending, that's a confirmatory decision that can be reviewed.
Yes.
And then it's for the local authority to carry out the review and potentially there's scope for an appeal. It doesn't sound like such a real problem.
So I understand the force of that point, and let's say that the appellant had strictly limited his request to review suitability, and in fact the review decision hadn't mentioned discharge of duty, or only in a final comment.
It's stating the consequence rather than a decision. It's just saying that's how it is.
Yeah. And then the applicant would have been notified by the eviction decision. But
They were notified of the decision.
Well, that's a confirmatory decision, isn't it? He got an eviction decision, and that always happens.
Yes.
Every case that happens, unless they're homeless at home while waiting for an offer under Part 6, which occasionally happens. I think my concern about that route is I want to try my best to get guidance from the Court of Appeal which says that local authorities, if that's the right answer under the legislation, which says that we know when the time limit starts ticking for review. And I think your lordship decided in Barno that's the offer letter.
I can see the problem. It's because we didn't actually have to deal with the time limit in Barno.
Yeah. But if it's reviewable, then it's obvious. The answer is obvious. So, or is the answer if you notify the applicant of an offer, he has a right to review that. So what if he doesn't? Well, there's no review, but then the local authority notify the applicant, our duties, there's no review on discharge, but only on suitability. Then the local authority say, in a separate letter, in consequence, our duties come to an end. Then applying the various different principles which apply, one might say, well, you can't have another review on suitability, but you can ask for a review of that confirmatory decision on discharge of duty because it hasn't been done before. So I'm fine with that, but I do want to preserve the streamlined procedure, which is straight from the offer to the review decision on everything. If the applicant requests that.
Not quite. I mean, if at the stage when the applicant is not happy and wants a review of suitability, then there's no reason why they shouldn't put into the pot another argument as well.
Yes.
I think in Barno, I'm forgetting the facts of Barno, but of course, I think we did decide that there was a decision from the local authority which was itself reviewable at a later stage. Yes.
Paragraphs 53 and 59, my lord. I'm pretty sure.
Yes.
So
we didn't have to deal with the time limits.
No. And possibly we don't hear because it was all hopelessly late by the time the defence came in on any view of the matter.
I mean, yes, I mean, that is true, because Section 202 requires you the time to be calculated by when you receive notification of the decision, and there's no reference to being notified of the right to ask for a review.
There isn't. And my submission about that would be that clearly feeds into the suitable alternative remedy principle is not a mechanistic principle. I'm sure your lordship knows, far more experience than me of judicial reviews, but it is applied flexibly. I mean, it's relatively strict where you're talking about an appeal, a statutory right of appeal, but there still is room for flexibility. So if the individual had no idea that they had a right to appeal and was never told so, then one can see.
Well, except there are strict time limits for applying for judicial review.
For judicial review, well, we're talking about, but the suitable alternative remedy. My case, we were just talking, but I've been wasting my time not referring you to cases and things. But possibly, but you know, the suitable alternative remedy principle applies more broadly than just judicial review.
Sure. Yeah.
Yeah. If there's a statutory right of appeal, but it's not a mechanistic principle. So if the applicant say, I had no idea I had a right to appeal and no one ever told me, then there might be something in saying, well, this is an exceptional
Sorry,
case.
right to appeal or right to ask for a review?
Well, I'm thinking about this case because they got a review decision. But in the case you're putting to me, right to request a review, on the facts of this case, my learned friend's case is that the review decision was in fact an original discharge decision. But he still had a fantastic solicitor who is well known in housing law for his many years of service to the legal aid housing and counsel. So, you know, it's not really an excuse for not having requested a review. The fact is, they just thought they could run this as a Wandsworth and Winder without thinking about the suitable alternative remedy principle. That's what happened, I'm afraid. You know, there's no excuse for not having sought a review or appealed in my submission. That's the reality of this case. So I better refer you to a couple of cases, if that's going to be helpful.
Yeah.
So I think I've basically dealt with the point. My basic submission is that if you look at the legislation today, my learned friend says he's looking at everything together, but he's really just looking at Section 202 and therefore saying this all must be subject to an obligation to notify without and disregarding what's actually in 193 and its history. So I say if you look at Section 193 as it is today, it encourages the view that the duty to notify the applicant of the discharge of duty is prospective at the original stage. In other words, it goes in the offer letter. And then what I try to develop in the skeleton, so I've set out some of that history in the skeleton. And then my point about the review is that the Mohammed principle is that a review is a reconsideration. So on a review, the reviewer takes into account facts which have happened between the date of the offer.
Depends on whether you accept it or not, doesn't it? Anyway.
On suitability, yes. But you can certainly, well, that's a point about fairness, but certainly as a matter of principle, on a review of cessation of duty, the reviewer can take into account the fact that the offer has been accepted or refused. So in my skeleton, I've referred to Temer and Hackney. I don't know whether we should look at it. Perhaps we should look at it very briefly. So that's 17 in the authorities. So I don't know if you know about this case, but decision of the Court of Appeal, point was original decision not in priority need, request for a review, then the applicant got housing, review decision, we still don't owe you the duty because you're not homeless, upheld by the Court of Appeal. And I only need to touch on so within the judgment of Lord Justice Jackson, page 329, paragraph 35. So it's 34, 35. Yeah. And then Lord Justice Lewison sets out a slightly longer, kind of more fundamentalist explanation of that consequence, drawing on the difference between you have to identify what the issue is under section 202 that's being reviewed, or the question that's being reviewed under section 202, and various issues and factual issues which might be subordinate to that. That's at 77 to 79, 334 to 335. And I'm making this point really just to emphasize there's nothing heterodox about what I'm suggesting, about going straight from the offer where it's a prospective discharge to the review decision where it's a retrospective discharge. The facts have changed. The question is the same. It's a statutory question. And then Wasami, in terms of the case law, I think my main point on Wasami is I thought I'd spotted something that no one else had spotted. It begins at page 129. So I think my lady and your lordships looked at page 135 in the authorities bundle. So opposite letter E.
Sorry, which page of the original report are you on? Because naturally I've vandalised the papers and haven't got the page numbers of the bundle.
135?
No, sorry, the original report rather than...
Oh, sorry, yes. 702.
Yeah.
So letter E, 702. So that's when we've got the offer of Part 6 accommodation, 27th of January 1998. 30th of January 1998, they visit and they refuse. But then we've got a letter dated the 5th of February 1998. And it concludes with a warning. The council urges you to reconsider your proposed refusal and to arrange to accept the offer by the 9th of February 1998. Otherwise, the offer will be withdrawn, etc. If, and then, penultimate line, if you are still refusing this offer, and so forth. And what Lord Justice Chadwick said about that over the page one, so it's report 703 in the bundle 136,
yeah.
Letter B. The thrust is clear enough. The council was intending to treat the refusal of accommodation as a ground for bringing the duty imposed by section 1932 to an end. So it wasn't saying it actually ceased. It was saying if you don't accept it, if you maintain your refusal, then our duty will cease. And in actual fact, the review decision, 26th of February 1998, referred to opposite letter F on page 703, page 136 in the authorities. Again, held the offer open until the 2nd of March 1998. What Lord Justice Chadwick says about that is that it was clear from that letter, the result of the review is the local authority was confirming a decision there was no longer any duty. But perhaps I'm trying to make too much of this, but in my submission, probably on a correct analysis, both of those were prospective discharge decisions. So the ultimate conclusion that there is a right to request a review, even going back as far as Wasame, that was applied to prospective discharge decisions. So clearly what the Court of Appeal decided was there was a right to request a review of that decision, which was intending to treat the refusal as a discharge of duty. There may be some textual support for that on page 139, last page of the report. The paragraph which begins, "I am satisfied." In the context of this legislation as a whole, it was the intention of Parliament that decisions as to matters which, if they existed, would cause a duty to cease, are decisions which can be the subject of a request for a review, and therefore appeal 204. For those reasons, I take the view the judge was wrong to decline jurisdiction. Then we've got I wonder whether I need to go to Hanara Begum on, I think let's go straight to Ravichandran, which is in the authorities 13. Page 235. By this time, the Act has been amended, so 1937 is substantially as it is now, but not with the requirement to notify as to the consequences of acceptance. So the facts were final offer of accommodation. So that's 122 of the report, page 240 in the authorities bundle. Final offer does all the right things. It says the council is, paragraph 7, council has satisfied the accommodation is suitable, it's reasonable for you to accept. If you don't take up this offer, the council will no longer have a duty. It's all correct. Then there's a request for a review. We've got on page 241, so that's 123 of the report, a decision of the 10th of October 2008. Review decision, it's suitable. And it's followed by another letter, 8th of January 2009, that's paragraph 10, which says permanent discharge of duty. And that's the point at which, over the page, 124 of the report, 242 in the authorities bundle, the council is therefore ending its duty. But that was an original decision. The suitability decision did not purport to include a review of discharge of duty. So the submission on behalf of Lewisham that there was an alternative case, the authority advanced that they could rely on subsection 5, even though it was a Part 6 offer, and that was rejected. But the relevant submissions begin at paragraph 28. This is Lord Justice Stanley Burnton, who delivered the leading judgment. It's page 248 in the authorities bundle. So the submission by Mr. Arden QC was that the only decision, in consequence of the amendments, the only decision the authority has to discharge of duty was a decision prior to the making of the offer. In other words, the only decision was prospective, and that the history of the legislation is summarised there. And this is the origin of the judicial gloss or automatic cessation, paragraph 29. Submission was section 1937 now provides for automatic cessation of the authority's duty in the circumstances specified, if the circumstances specified they have occurred. It's no longer dependent on any decision, and therefore was irrelevant that Lewisham had actually produced confirmatory decisions, as we're calling them. And then by way of riposte, Mr. Latham for the Ravichandran submitted that it was implicit in the amended statutory provisions that following refusal of an offer, the authority must notify the applicant that the authority regards itself as discharged from its duty under the subsection. That's my learned friend's case, by a different route perhaps. And then Lord Justice Stanley Burton continued paragraph 13 our judgment. Both Mr. Arden's submission as well as Mr. Latham's perceived need to address it by arguing for an implied notification provision are misconceived. And then there's an analysis of Wasami. Paragraph 31 there's a reference to the original provisions of section 1937 providing for automatic cessation, by which can only be meant the duty ceases without a further notifiable decision on cessation of duty.
Sorry, you're on paragraph 31, are you?
Yeah, so it may not matter this, but it's what does automatic cessation mean? And so Lord Justice Stanley Burnton is referring to the original 1937,
yes,
which we saw imposed an obligation to notify that the authority is satisfied as suitability and reasonable to accept. Lord Justice Stanley Burnton refers to that as automatic cessation.
He says once the conditions are satisfied, the duty is at an end.
Exactly. So it's the same point. It's the duty ceases without a further notifiable decision that the duty is ceased. So he's actually being very consistent with his application of that phrase. And this is the origin, this paragraph is the origin of the effect of Wasami's case is that its decision taken then, even if only confirmatory of a prior automatic discharge, was reviewable under section 2021B. And in essence, that's the point your lordship was putting to me earlier. But Mr. Arden's submission, paragraph 32, this is the point I've made to your lordship, my lady, that you can't have endless reviews of the same issue. So Mr. Arden submitted, this would be produce an absurd result because the local authority couldn't review suitability, reasonableness and discharge at the same time. We do not accept that criticism. If following the making of the offer by Lewisham, or at any event once there had been a refusal of the offer, there had been a review at the same time of both suitability and reasonable to accept, as well as the decision prospectively to discharge the making of the offer, ... they could have been dealt with at the same time. And then there's no further review. The problem in the present case is that until January 2009, there was never an invitation for a review of reasonable to accept or prospective discharge by the making of the offer. And no such review was in fact carried out until then. The only review was of suitability. So that's my basic submission is the local authority, in this case, didn't fall into that trap. They may not have done it perfectly, but there was a review of cessation of duty. at the same time as suitability. So they did it right. And the principles are then summarised at paragraph 35. And the key ones are subparagraphs 6 to 8, which are on the final 2 pages of the report, which I would invite you to read. And then ask me any questions you see fit.
So where do you get to on your case?
Where does that take me to? So the Court of Appeal clearly rejected the argument that there can only be a review of a prospective discharge of duty decision. They also clearly accepted there can be a review of a prospective review decision contained in an offer letter. That appears from paragraph 35(6).
Sorry, yeah, just say your first sentence again. I'm not
So
sure.
the first one is they rejected the submission
Yeah.
that there can only be a section 2021B review of a prospective
Yes.
discharge decision. That was Mr. Arden's QC's submission. They rejected that. So here,
So your second proposition was that there can be a review.
but there can be a review of a prospective discharge decision contained in an offer letter. That appears particularly from 35, paragraph 35, subparagraph 6. Furthermore, subparagraph 7, it's desirable that all these issues should be reviewed at the same time, but the applicant should be so informed. Now that guidance is not particularly based on any legislative provision, but it clearly makes sense. That's the ideal, because then that ensures that the procedure is fair.
Is this coloured a little by the fact that the legislation in relation to 7F has changed? They're dealing with a differently framed 7F, aren't they?
No, I don't. Oh, 7F. Your Lordship, I believe it's the same 7F.
You see their version of 7F, page 121 of the report. That's not what we have now.
It's pretty similar.
So what?
I mean, it is a little bit different. I accept that. I mean, in particular, the reasonable to accept point has become.
Which is what they're specifically dealing with.
Yeah, that was the point that wasn't really dealt with by Lewis. That was the problem that Lewisham had. They didn't deal with the reasonable to accept point properly in their original review decision, and that did give rise to the problem in that case. But the construction of the legislation is a general one. So if your Lordship's putting to me that subsection 8 has changed, that makes quite a big difference. Apart from that, it's pretty similar.
It's only, it's a bit perplexing when you see all this stuff about reasonableness. And
Yeah.
you realise that the legislation said something different at the time.
It did. So that's only in a footnote in my skeleton. But reasonable to accept used to be quite a big issue, as interpreted by this court in a case called Slater. And it is no longer, and possibly Parliament clarified it to mean what they always intended it to mean, which was it's just about whether or not you can bring your contractual obligations to an end in your existing accommodation.
So one can readily see how, when you have the two requirements, suitability and reasonableness, there's scope for reviewing each.
Yes. But the general point is also cessation of duty. So they're saying, look, the system can work. You have a review of suitability, reasonable to accept as was, and cessation of duty all at the same time. That's the broad thrust of it. And the question is, how does that work in a normal case? And my answer is, broadly, how it worked in this case. If you ignore the long delay between the offer and the acceptance, this is a normal case. So when they said, so when Lord Justice Stanley Burnton, in fact, it's the judgment of the court, isn't it? On Stanley Burton on behalf of, yeah. So it's Lord Justice Stanley Burton delivering the judgment of the court. So that he then said in subparagraph 7, if it is intended that this will take place at the same time, the applicant should be so informed. Which is clearly good practice guidance and a very good idea, because then there never can be any complaint that what's happened is unfair. If you're faced with someone much later defending possession proceedings, you can say, well, there can't be any scope for the suitable alternative remedy principle because we told them what to do and it's clear they had a fair opportunity. I'm not sure whether this overcomplicates things, but there is another procedural solution which you may or may not be aware of, which is if a local authority carries out a review, and during the course of that review they consider there's a deficiency in the original decision, they serve a minded decision, which is a statutory technique to ensure the fairness of the procedure when something new crops up in the review that wasn't addressed in the original decision. And we haven't provided that, but I'm sure that Lord Justice Lewison sets out the predecessor, which is identical. We used to call them Reg 8.2, they're now Reg 7.2 notices. Page 336 in the authorities bundle, paragraph 83 of the decision in Temer and Hackney. There's a whole load of case law amazingly on that one provision, including a case of Me Too and Camden, which is referred to earlier in Lord Justice Lewison's judgment. But I think we agree, I'm looking at my own friend here, that a deficiency includes where the original decision was absolutely lawful, but it didn't address an issue which has cropped up on the review, and it's necessary for a minded decision to be served to ensure the review procedure is fair. And one can see in a case like Miss Bubbs, on my case, Miss Bubb disputes, and perhaps not her case, but anyway, someone else's case, where they dispute the discharge of duty and they raise a new point. I mean, one might even have said in this case, if you're going to say, if the local authority is going to say that the procedure was correct because of new matters that we haven't previously been informed about, they can serve a Reg 7.2 minded to decision within the review procedure. It's a subsidiary point, but I'm just making the point that the review procedure can be tailored so that it is fair. Notwithstanding my submission, you can go straight from the offer letter to the review decision. The point which may be put against me based on Ravichandran. Let me just find it again. Is that, so page 251 of the authorities, paragraph 35.6, within the judgment of the court. So, second sentence, if the review takes place before refusal of the final offer of accommodation. So clearly anticipating possible review of an offer, cessation of duty decision in an offer. Then it says, if the review takes place after the refusal of accommodation, it will be a review of the authority's confirmation that its duty has ceased by virtue of satisfaction of statutory preconditions. And that's what I was looking at when I took you on that little excursion into what is now Reg 7.2. So, you know, we're not considering this as a statute, but my learned friend might say, well, actually, the Court of Appeal was there anticipating an offer letter refusal. The decision, he says, that we should have given the appellant in this case, our duty has ceased, and then a review. My basic response to that is you shouldn't construe this as a statute. And that on a correct analysis of the legislation, there's no need for that extra stage. And further, that there is a mechanism within the review procedure regulations to ensure that any review is fair. if new issues crop up on the review. So that takes us to Barno, which we, amazingly, I don't think we've actually looked at yet. So the key points in Barno, there was an offer. There we are, page 530, paragraph 13 of my Lord's judgment. Offer 11th of June 2020. This is a PRSO, private rented sector offer, and the offer letter contains a prospective discharge decision. There we go, paragraph 14, that's there set out. I must inform you in writing of the following. There was a technical defect with that notification, which we don't really need to be concerned about. It was then refused by a WhatsApp on the 14th of June, that's paragraph 16 on page 531. Council replies by an email, your temporary accommodation has been cancelled from tonight. Common ground was actually she refused it the following day, I think, if one looks at paragraph 18. And there was then this cancellation letter of the 19th of August 2020, referred to at paragraph 19. Again, I think it was the COVID pandemic intervening, rather like in this case. There followed a request for a review, paragraph 20, but it was rejected as out of time. Once he's at paragraph 21. Much later, in fact, something like 3 years later, the solicitors for the applicant wrote to the local authority saying, will you agree that the main housing duty is continuing? So one can well see why timing issues weren't really an issue for your lordship. And of course that succeeded in a judicial review at first instance, paragraph 27. What was the answer? Because there was a technical defect in the procedure, because the offer letter didn't correctly inform the applicant as to some of the consequences of refusal. And in a sense, what have I been standing on my feet for? Because I've got paragraph 32, page 535. Got a nice little analysis of suitable alternative remedy. Well, the only thing I really added to that in my skeleton was at no, I've got a couple of small things to add, which I'll do in a moment. But we've got a nice analysis of suitable alternative remedy, paragraphs 32 to 35. Then we've got a lengthy analysis from paragraphs 39 to 53 of everything that was decided in Wasami and Ravichandran, including, importantly, the conclusion, paragraph 52, referring to whether you need a retrospective discharge of duty decision, in essence, is the point. And then paragraph 52, my lord says, the Court of Appeal did not hold in Ravichandran that the duty of a local housing authority under section 193 would not come to an end under section 1937 unless it decided that the conditions for that had been satisfied. But rather, the decision to that effect was reviewable under section 2021B, even if only confirmatory of a prior automatic discharge. The court thus recognised that there could have been prior automatic discharge, and further commented that in its unamended form, section 1937 had provided for automatic cessation, albeit at a later date, i.e. after notification. We've looked at that. The court also referred in paragraph 35(6) to the possibility of a review of the decision of the authority as to discharge of its duty under section 1937 by virtue of section 2021B taking place before refusal. So again, that's something I highlighted. My lord then went on, what may matter more in this context of the present appeal is, as the judge recognised in Ravichandran, the Court of Appeal proceeded on the basis that a decision prospectively to discharge by making the offer can be the subject of a request for a review under section 2021B of the 1996 Act. Then there followed a discussion and recording the submissions made by Ms. Davies of the King's Counsel. Paragraph 58 on page 543. In essence, the point is there's no obligation to notify the applicant of cessation of duty following refusal. But even if that's wrong, the applicant had a suitable alternative remedy of requesting a review of the offer letter. The ultimate conclusion is paragraph 67 to 70. So it turned on suitable alternative remedy principle. In other words, if Miss Barnard wished to challenge the cessation of duty, she should have requested a review, either of the offer or the confirmatory email. So, applying that case law to the present case, I say the offer notified the appellant of a prospective discharge of duty pursuant to section 1936C. It also covered the other requirements in subsection 7, particular notification of the consequences of acceptance, and also the conditions in 7FA, particular that the local authority was satisfied the accommodation was suitable. That attracted a right of review, as we've just seen. So Barno decided. Also, Ravichandran, I say Wasame arguably also follows from that, because the original decision in Wasame was a prospective discharge decision. But in any event, one or more of those decisions gets me home on that. Then I say that the review decision of the 20th of July 2020 was a retrospective discharge review decision. And I've got three ways to get home on that. The first is, I say, on a correct construction of the appellant's solicitor's email of the 10th of June requesting a review, and or the appellant's own email of the 1st of July 2020, they raised issues about whether the appellant freely accepted the offer and whether the offer process was lawful, which were relevant to the section 2021B question. You've also got an authority for the proposition that a request for review should be broadly construed. That certainly applies where the applicant is acting in person. I'll just give you the reference to my skeleton. That's paragraph 74 in the skeleton, refers to that authority. Alternatively, I say that if you read the offer in conjunction with the reminder letter, the respondents did enough to inform the appellant that he had a right to request a review of cessation of duty. And in those circumstances, the respondents were entitled to and did address the cessation of duty issue in the review decision. And I accept that in an ideal world that they would have been even more explicit or clear about that. But I say the procedure wasn't unfair as a result of any failure to set that out even more clearly. Thirdly, I say, and we haven't actually looked at paragraph 38 of Rohanara Begum, but I say that the appellant had the option of appealing the review decision, in essence, because it said it was a review decision and she could appeal it. So for any of those reasons, three alternative reasons, the appellant had a suitable alternative remedy of appealing the review decision. Do we need to look at Rohanara Begum briefly? Perhaps I should. Just to make sure. So it's authority 11. Probably don't need to spend much time on the so it's page 215 in the authorities bundle, paragraph 38. The judgment of Lord Justice Neuberger, with whom the Lord Justices Ward and Tuckey agreed, and it seems to me that in the light of the way in which the council expressed themselves in the letter of the 22nd of May 2002, it would have been open to the respondent, subject to any time limit problem thereafter at her election, either to request the council for a review on the basis that that is strictly correct analysis, or to appeal to the county court on the basis that this is what the May 22 letter said she could do. So that was the point, that the May 22 letter couldn't have been a review decision, because at that time you had to notify the applicant after refusal. And I've developed that slightly at paragraph 76 of my skeleton. In essence, I say the provisions of the Act which require there to be a reviewer for the benefit of the parties, so that they are able to waive it. And there is a decision of the Court of Appeal, which I referred to my skeleton, page 19, footnote 6, which is almost the converse position, which is, although the statute says you can't review a review, the parties can agree to scrap a review decision if they do so clearly, and do another review decision which will then be appealable. And that has been decided by this court in a case called Dimitri. So I say, if they can do that, they can also agree to treat a decision which isn't a review decision as a review decision. So in any one of those three ways, the appellant had a suitable alternative remedy of appealing the review decision. And in those circumstances, I think you were taken to both Rahanara Begum, the key paragraphs 32 to 34, and Godson approving that, in which my Lord Justice Newey sat with Lord Justice Lewison. I've referred to those, paragraph 78 of my skeleton. And once one appreciates what actually happened in this case, even if my learned friend's right that there was some kind of stage in the process missing, it's very closely linked. All 3 points are quite closely linked. It's like, well, what is the point of this additional stage in the process? That goes to the construction of the legislation, whether anything unfair has happened here, so that the suitable alternative remedy principle doesn't apply, and it also goes to the so what point. I mean, they're all quite closely linked. They're conceptually distinct. But my learned friend's point is a stage in the procedure was omitted. And I say, no, it wasn't. In any event, his client could have appealed. And thirdly, it wouldn't have made any difference. So the only two bits on suitable alternative remedy that I've really got to add to my Lord's analysis in Barno, I've got a section in my skeleton where I deal with it, and I'm content to stand by that. I just briefly wanted to look at Glencore, because there's quite a good analysis, quite an in-depth analysis by Lord Justice Sales, which has been approved by the Supreme Court in the Father and Worcestershire County Council. So that's in the authorities. It's paragraphs 54 to 58. Yeah, so there were just 2 points I wanted to pick up. My lady observed during my learned friend's submissions that you don't need an ouster clause for the suitable alternative remedy principle to apply. And my lady has this decision of the Court of Appeal behind her. Paragraph 54, page 426 in the authorities bundle. In order to evaluate these submissions, it is necessary to consider the basis for the suitable alternative remedy principle. The principle does not apply as the result of any statutory provision to oust the jurisdiction of the High Court on judicial review. In this case, the High Court, and hence this court, has full jurisdiction, etc., etc. It's not ouster. It's something else. And the other point I just wanted to add as a footnote. One of the, so the leading case that I've referred to is in Re Preston, which is kind of this line of case law comes from. And one might ask oneself, although on the facts they decided it was an exceptional case. And one might ask oneself, why? But Lord Justice Sales provides the answer at paragraph 58, page 427. So where it begins, right-hand side, in that case, the allegation was, it was legitimate expectation. Although the allegation was not made out, the House of Lords was prepared to accept that such a claim could be made by way of judicial review. In fact, the tax appeal process would have been incapable of dealing with such a claim of unlawfulness on the part of the commissioner. So, one can easily see why, therefore, suitable alternative remedy doesn't apply, because it can't be the basis of an appeal. All the tax appeals are all on the merits. So the tribunal, or the commissioners, I think it's tribunal now, tribunal now just decides for itself what tax is due. And then I mentioned earlier that one additional point I picked up as a footnote to my Lord's judgment in Barno was in the Father and Worcestershire. I've referred to this at paragraph 89 of my skeleton, perhaps we should just look at it very briefly because it's directly relevant to my learned friend's winder point. So this is at page 514 in the authorities bundle. And it's paragraphs 64 to 65. So I just invite you to read that. So the way I've pitched my submissions, I hope reasonably consistently throughout, is that the appellant had a fair opportunity to challenge discharge of duty via an appeal under section 204. And note that at paragraph 65, Lords Sales and Stevens, with whom everyone agreed, made the point that if an individual has had a fair opportunity to participate in the proceedings leading to the making of that order, that's a care order in that case, an attempt to bypass the usual procedures for challenging the relevant measure, whether by judicial review, appeal, or other forms of procedure, is not justified. So that's, whilst it's an authority for the more general application of the suitable alternative remedy principle, in that case, challenging a care order via writ of habeas corpus.
And Mr. Bates is not getting very long to reply.
No. So, in response to his section 184 submission, he says section 184 applies to discharge decisions. I say that's completely wrong. And I've set out my answers to that, paragraphs 95 and 96 of my skeleton. I'll stand by that, subject to one brief addition, which my learned friend provided me the opportunity for, and I'm afraid I can't resist, which is having regard to my Lord Justice Newey's comments about masses and masses of cases where the duty hasn't actually been discharged because no one's been doing what he said. Which ought to happen. Just very briefly, page, I think I start on 368 of the authorities bundle. So this is the decision of the Supreme Court found in the application of N against Lewisham London Borough Council. The judgment we're about to look at is Lord Hodge, with whom Lords Wilson, Clark and Toulson agreed. And it's one specific point. Page 383. So, this is just where paragraph 53, roughly opposite the upper hole punch, Lord Hodge says, in my view, the settled practice principle of which Lord Carnworth writes is available where there is ambiguity in a statutory provision. But there was no ambiguity in that case. And then at page 393, Lord Carnworth sets out the settled practice principle at paragraph 95.
Maybe this Bates does need some.
Yes, so my parting mark is just that this novel interpretation based on Section 184 would overturn previous practice, and therefore the settled practice principle applies if you are of the view that this is an ambiguous provision.
Yeah, thank you very much. Mr.
I put this case in the bundle. I suppose I can't complain that it's slipped in between the ribs at the last minute. I'll come back to that in a minute. Well, I'll try and pick up some of the other points first. I will keep my replies quite short, and I'll make sure I meet the time. Primarily because this is actually one of those cases where I think I can reply within the proper rules bit, only on new points that did not arise before. I'm not going to repeat everything I said about how the Act works. I think you want to clearly understand the different constructions we're putting to you. What's really happening, it seems to me, is that there's a factual issue about the reading of the material, and then there's two conflicting statutory interpretations, both of which, as I put to you, had difficult questions back from the bench. Can I do the factual point first? My own friend looked at the various of the decisions and the reminders, etc. I just need to look very briefly because he slightly glossed over this when he came to it. He took you to, in the main appeal bundle, behind tab 29, page 241, which is the review decision that I say is actually the first time you have a decision that the duty has been discharged. That's the dispute between us. And you recall that one of the questions arising from questions from the bench between the two of us is, well, what is this? Is this a suitability review or is it something else? It's paragraph 25 that he took you to, and then slightly tailed off towards the end of reading his paragraph 25, because the last two words in paragraph 25 are, I think, must be quite important. The review officer then sets out in italics that long, slightly confused email that my client sent acting in person. The review officer read those as relating to suitability. Now, plainly, this court is going to have to look at correspondence and form its own view on what actually happened. I think I will probably accept without prompting that what a letter is must be a question of objective legal fact rather than what you describe it. If they describe it with the wrong provision, I can't change what it is. But it is telling that the author thought they were only being asked to review suitability, and that very long email that my client sent was treated as a suitability review. The second point I wanted to reply on, I should say at the outset, I'm not sure if this helps or hurts me yet. I haven't been able to work it out, but I'm sure I agree with something my learned friend said. I think it's important that I record I don't agree with it. If I've understood what he was saying properly. I think what he was saying, if you go in the authorities bundle behind tab 1 to page 6, I think he says by concession that subsection 7 did bite on his clients. The difficulty I have with that, I'm not sure this is a good point or a bad point for me, but the difficulty I have with it, if you look at the wording of subsection 7, the local housing authority shall also cease to be subject. So I don't think it is intended to be parasitic on 1936C. It looks like it's a freestanding method of discharge, rather than something that lives with 1936C. And I'm not sure whether that helps or hurts me, but I don't think I can agree with his concession for that reason. Finally, before I come to the CN point that my own friend ended with, a series of scenarios were put backwards and forwards. Can I just give one? It seems to me, if this scenario is right, if my analysis of the scenario is right, this must be why I am writing my substantive argument. An offer is made it is accepted, but with a review of suitability. So far, so common. On review, it is found by the authority that the property was not suitable. But because of how my learned friend reads 1936C, we've accepted the offer of accommodation under Part 6, and so the duty has ended. But we've accepted an unsuitable property, and you can only discharge your Part 7 functions by offer of a suitable property. So, for that reason alone, it seems to me that's strong support for the idea that you need two separate decisions. Now, my own says that's not his construction. I'm not putting words into his mouth. I'm just trying to think through other scenarios that were put. If 1936C operates as an automatic discharge when you accept the property, that means you could accept something that's unsuitable, which should not be possible under Part 7 because you can only discharge through suitable accommodation. It's why you have the two stages. And then CN. Sorry, what paragraph was it in CN that you extended us with?
95 is
95, you can't.
Yeah. Page 393.
That's very kind of you. I should know this one. I spent 3 days looking at the back of my learning friend's head, and I was much further back in Council's Row than I'm now allowed to be. The settled practice approach doesn't really help because we know that the amendments to the Housing Act, I think we both described them as piecemeal, lacking any considered consistent process. What we had is the 96 Act and then a series of almost whack-a-mole type problems as new situations arose. So we haven't got a situation there where, as was what was being grappled with in CN, where you've got provisions that are in one statute, then consolidating legislation, then updating legislation. It's not quite that sort of scenario. As for the suggestion, there's been no authoritative interpretation by the lower courts. That's the point of this appeal. There have been cases that touch on it, and there have been cases that might be said to assume one particular state of affairs. But neither of us have an authority which speaks directly to this question. And then the final point there, has the settled interpretation effectively allowed business to be operated without causing serious problems or injustice? I end with what I hope isn't too cheeky a point. The fact that the same problem has come before this court twice already this year, in Banno and this one, suggests that whoever is right, there is a growing awareness of a problem in the legislative drafting. So I may well lose the appeal, but respectfully, I don't lose it for the reasons that I was on the losing side in CN. I have to turn my back for a minute, please. No. My lord, my lady, I can help with anything else.
I don't take any more questions, so thank you very much. And thank both of the two of you with speaking roles very much for your very helpful submissions, and also those behind for their contributions. As you anticipate, we're not going to give judgment here and now. You will receive the draft in the normal way for you to point out our typing and similar errors, but not, of course, to re-argue the case. we'd be grateful if at that stage you'd seek to agree an order dealing with consequential matters. If there are points on which you disagree, could you please have brief written submissions, and we would expect to settle the points in the order that we make. Lastly, although I know you will be extremely familiar with this, it is a matter of continuing concern to this court that the embargo is complied with. I think you've already supplied a list of those to whom the draft judgment should go. If you think of anybody else who you think should see it, you obviously need to come back and get permission for that. It is all too common for that not to be complied with, and that is a matter of great concern. So please make sure it is. But anyway, thank you very much for your very helpful submissions.
Well,